are now recording. This is the meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I think we should wait to take roll because I think we assume that Fariba is joining us. And we have one attendee. I don't know if we should, do you want to do a call for public comment?
Sure.
Someone on the phone. So if the attendee on the phone, if you'd like to make public comment, you can press *9 and that will indicate a raised hand. I'll give you a moment to do that, and otherwise we can just get started. Oh, okay, the person is raising their hand. I'm going to allow them to speak. You can go ahead and start. Hello? It looks like you're muted. You want to speak, the person calling in on the phone? You can unmute yourself, you can speak.
Okay. Well, maybe if, oh, are you coming on?
Well, they've been allowed to speak, but I don't, it looks like they're still muted.
Okay.
So
If you,
I'll go ahead, we can come back to them later.
Okay. So Tom, if you could introduce yourself, and Amos, introduce yourself. Well, it's going to be a great, I think we're going to get a lot done today. And then what I'm going to put up on the screen is the document, Tom, that I shared with you, and Amos, you've seen kind of the notes from our proactive regulation discussion. But Tom, go ahead.
Sure. So I worked for the National Center for State Courts for about 15 years as their Vice President of Research and Technology. I retired a year or so ago, although I'm still working. And my main activities now are working with Utah on their Sandbox project.
Great. My name is Amos Heartstone. I'm one of the members of the working group, I think appointed or recommended by the California Commission on Access to Justice. So I've been serving on that for a number of years, and my day job is with the California Department of Justice, the Attorney General's office in consumer protection issues. And I have some experience on licensing and regulation issues. So that's, I think, how I ended up on this subcommittee.
All right, great. So, and Linda, if you just want to introduce yourself to Tom. Or if you, maybe you did before I got on. You're on mute. We can't hear you. Linda is providing staff support, as am I. I'll introduce myself.
Sorry.
That's okay.
Hi.
All right.
Linda Katz, and I think that's Justice Petru, who's I looked up the phone number, so I'm not sure. I can't promote her phone number to the to a panelist. I'm Linda Katz. I am staff in the State Bar's Mission Advancement and Accountability Division, and I'm lead staff on this project.
All right. Can you see this Word document I have up?
Yep.
All right. So first, Amos, since Fariba is not here, I want to confirm the risks. So we had originally risk 1, a worse legal result for the consumer than they would have had. We had risk 2, consumer overpays. And then based on our last discussion at the subcommittee, we had consumer receives incompetent legal services and consumer receives unregulated legal services. Did I capture that correctly as the 4 risks that you and Fariba identified?
Yes, I think, yeah, if I could comment on them briefly, but I think those are the categories. So I think they were excessive fees. So you have that as overcharged, right? So they have
Mhm.
that one. Competency, which you have as number 3.
Mhm.
So I think those are the 2 correct ones. The other one for unregulated legal services, I think that was creating, yeah, I'm not sure exactly how we frame that, but the idea is there's going to be potentially a lot of fraud by unlicensed people who prey on this new licensed area. And I think we dropped what is number 1, the next best alternatives. At least I think we changed that or characterized that as maybe some sort of evaluation that we might want to do, but not necessarily the direct target of our regulation. Does that sound familiar? That's
Um,
what my notes say.
yeah, it's perfectly plausible that I got it wrong. So 3 risks that we are seeking to kind of protect against in this proactive regulation scheme: excessive fees or consumer overpays, competency or incompetent legal services, and the receipt of unregulated legal services.
Or fraud by non-licensees.
Fraud by non-licensed people.
Fraud by and I think the idea, as we described it, was creating a baseline of behavior for licensees, and that might be the competency one. And I think I think I mixed evaluation with regulation, because to the extent we're going to want to be collecting information, it's also to evaluate the success of the program. Are we doing what is intended? Are we addressing the justice gap? Impact on courts or other people. So in my mind, I have it all related, but I think we separated out these 3 targets of regulation.
Okay. And here up in the top portion of this document is where I have the objective of regulating, which I think could go to a little bit of the evaluation question as opposed to the risk question. But with that, Tom, so you've had a chance to look at this. You've done a lot of work in this regard in Utah. Where we ended the last time was sort of, okay, great, we've identified these risks. Now what? How do you actualize this into a proactive regulation construct? And what exactly does that mean? What would it look like?
Yeah, so maybe I should just add to my bio one more sentence, which is, yeah, I worked with the Utah program and the Washington State program, and also with the National Center people who have just published a draft version of evaluation measures for these kinds of programs.
Oh,
So we're pretty heavily involved still. It would be easiest for me to kind of start at the top and work down, and you'll see where the logic flows from my comments. So if it's okay with you, I have a couple comments about your regulatory strategy, and then your objectives, and then your risks, and then the data collection. Is that okay?
sure.
All right. So let me start with the regulatory strategy. So people have so far until now adopted one of 2 regulatory strategies. They've either done the traditional approach that's always been applied to lawyers, so experience requirements, training requirements, certification requirements, and rules about allowable behavior, all intended to prevent hypothetical harms on the front end, and then minimal to no regulation after that. And in fact, that form of traditional regulation has been extended to every LLT program to date until your proposal. And then on the other side of the fence are the sandbox-like non-traditional provider programs, which to date have been regulated in a completely different way, or at least proposals to regulate them completely differently, by empirical data of consumer harms. And so nothing hypothetical, they actually collect data, evaluate whether harms are committed or not. those two approaches are not very compatible. And so I was surprised to see that in this program, you're proposing to do a hybrid of both, which would not only be unique, but would be the most onerous strategy for regulating this role. So I was curious, what is it about this role that causes you to impose more regulation on it than anybody has on anything else?
So I'll take that first, but I welcome other comments to this. So I think the knee-jerk reaction, and I think we should be, consider this further, but the knee-jerk reaction is to do the traditional regulation, which is license requirements, education requirements, MCLE requirements, and a complaint-based discipline system. I think we are looking at this proactive regulation and data collection as sort of a way we could be progressive about this and be, thinking new ways to address potential consumer harms, with, I think, a goal to make it not too onerous, but to have like an annual assessment and some data collection that we would want to do anyway on evaluation. So that's my understanding of why we are, and it sounds like bar staff and others have identified proactive regulation as something that really could fit well as we're creating a new licensee program. So I don't think it's intended to be too onerous, and I think we would certainly want to mitigate that and address ways to not be too onerous. But I think we would, if we're creating a new licensee program, collect information about its effectiveness and proactively try to address any public harm or consumer harm.
Yeah.
And Tom, if I can ask you a question, because you said something similar to me and I was kind of surprised by it. So in sort of the alternative paradigm, are you saying there would be no licensing requirement? There would be no other regulatory requirement, like you've got to do a minimum number of CLEs, and there would be no system to receive consumer complaints? Those are all part of the traditional discipline system. Instead, the only thing you would have is data collection and auditing.
Yeah.
Like when you, because I can't imagine a world where you wouldn't have any licensing requirement, for example, or where you wouldn't have any repository for a consumer complaint.
Well, it's typical for sandbox providers to operate that way, though, even though it may seem amazing to you. And I'm not suggesting that that's what you should do. You're already imposing all the traditional kinds of requirements here. And those are probably what I would stick with, because by adding these other things on the back end, you are making it more onerous, whether you want to or not. But I really wonder, I don't mean this to sound so harsh, let me continue. I really wonder if there's a little bit of confusion between back-end regulation versus program evaluation, because I certainly can't imagine running a program like this that's new without program evaluation. And really, by collecting the data just once a year, I think you're really more wanting to use it like in a program evaluation than like a consumer risk regulation.
So I agree with that. And that's why I think, at least in my mind, I've combined the two, because I definitely think we'll want to do evaluation and collecting information. And for me, it sounded like some of the proactive regulation ideas, concepts fit into that, like a self-evaluation or reporting on, fees that are charged or things like that. So it could potentially identify issues that need further follow-up. But in my mind, it's combined. I think the last meeting we tried to separate them out to really be thinking constructively about whether we should be doing proactive regulation separately from evaluation.
Yeah, I think what you would normally find, I think, is that the back end regulation would be a subset of what you would do with evaluation. You would do it more frequently, but with less data and less measures. And I can talk more specifically about that as we go through.
I think that would be really helpful if we just take these risks and you talk about, okay, if you were going to do this as part of a regulatory scheme, this is what you would collect and how you would do it, or, you know, a potential option. If you were doing it for evaluative purposes, this is what you would do. That I think would be super helpful for us.
All right, I'll try and do that. So let's move
Tom,
next. Oh, go ahead.
So I totally agree, except I think the list is a little bit different or longer with respect to goals of evaluation. So I don't know if you want to go over that now, or I'm sure you understand that it would be a little bit different information we'd be focused on in evaluating the program.
Yeah, I think so. Or it would definitely have a lot of overlap, but it would definitely be more, like you say. So to kind of start getting at that, before we jump to the risks, let's look at the list of objectives on that first page for a second. So if you were just doing the back-end regulation, the proactive regulation from empirical data, what we've learned is you would want to keep your scope as narrow and focused as you could. It's really hard to do empirical regulation, and you don't want to be all over the place trying to regulate to 5 or 6 different objectives. You have to regulate to something clear and simple that has sharp focus. On the other hand, if you're doing program evaluations, you do want to look at all these things. So that's one clear difference right out of the gate. If you were doing the kind of empirical consumer harm regulation that Utah is doing in their sandbox, then of that list of objectives, you would probably immediately concentrate on 2 and 3 in the reverse order, the consumer protection and giving consumers more alternatives. And if you were to do that, I would say that the competency of the services, which is a lower down objective, would kind of be a subset of consumer protection, and in reducing the justice gap or making services available is also kind of a subset of giving consumers more choices. So a little redundancy there. And then finally, the affordability objective normally in these programs would be achieved indirectly. It wouldn't be an explicit objective of the regulator to do that. That would be something that comes out of the market success of the program. Then finally, the first and next to last and last objectives, those are all things that would be perfectly appropriate to evaluate if you were doing a program evaluation, but if you're doing empirical consumer harm regulation, those would be out of scope. That sound okay? I'm going fast so I don't waste your time too much.
Yeah.
All right. So then let's go to the 4 risks, because I found those fascinating.
Or I think there are 3 now.
Yeah, but I'm still going to talk about 4.
Okay.
So I'm going to go through once from the perspective of consumer harm regulation, and then I'll go through a second time thinking about evaluation. So the thing that's really interesting to me about this is the first 3 risks that you came up with were almost identical to the 3 consumer harm risks that Utah came up with for their sandbox. You stated it slightly differently in each case, but in effect, they're almost exactly the same 3 risks. And believe me, they went through a long list of risks before they simplified and consolidated on the 3 that they had. But risk number 1, you stated quite elegantly, and they were afraid to it. I'm just being really frank with you here. They were afraid to state it quite that baldly because, to be truthful, the next best alternative was so bad for most people that they thought the quality levels would have been unacceptable to most politicians. So they didn't really state it that way. They stated it in the reverse way, which was that the outcome should be the same or better than the next best alternative. But it amounts to almost exactly the same thing. You can't decrease quality. It's got to be the same quality or better quality. So that one was pretty identical. Then your second one, where you have the consumer overpays for the legal service, they stated that one a little differently as well for 2 reasons. One is it stated a little more broadly, and the way they say it is the consumer pays for in inappropriate legal services or a legal service they either didn't need or didn't get. So they're paying for something that they didn't get, basically, which is a little stronger and a little broader than what you have there. You haven't included that in yours. They don't talk about overpaying for a service because in the empirical market-based form of regulation, the market decides what an appropriate price for those services are. So by definition, you're not overpaying. It's only in the kind of front end regulation that the concept of overpaying exists.
Can I ask a bit of clarification there?
Sure.
You're talking about the Utah sandbox?
I'm making comparisons to them, yeah.
So is that the sandbox for revising Rule 5.4? Or is that the parallel of a non-lawyer paraprofessional like the LLT?
It's both. That's a little confusing, but it's both. And it's even more confusing that Utah modified some of their rules for lawyers so that you can do some things differently now if you're a lawyer without going into the sandbox at all. And then if you're a non-traditional provider, whether it's a new legal services role or software, you have to go into the sandbox. But then if you're a lawyer or any of those other things, and you want to waive one of the rules that lawyers have to comply with, then you also have to go into the sandbox.
Yeah, I just wanted clarification because I can understand if you have like a non-traditional law firm that's, sort of, you assume the market will regulate what the prices are. But here we're in California for this program, there's a separate sandbox being considered, but this is specifically for a lower cost alternative, a licensed professional that would be a lower cost alternative to lawyers. So I just wanted to make sure the comparison was.
Yeah, and that's a good place to talk about program evaluation a little bit, because in Washington and Utah for the LLT programs, they did not try in any way to regulate what the role charged. Again, it's a market-based role, and so the roles charged in the market what they charge. But they were very interested, not from a regulation point of view, but from a program evaluation view, whether the amounts charged actually were less than lawyers, because it was a program goal that what the LLTs charge be roughly a third to a half of what they thought that was realistic, a third to a half of what a lawyer would charge in a comparable geographical area for a comparable task. And in fact, the evaluations in both states found that result to be true.
Can I ask on that point? So for that one, how did Utah and Washington, and how would you recommend we go about collecting the kind of data we would need in order to make that assessment? Is it an annual reporting on your fees, or are you going to get there later? Sorry.
Yeah,
okay.
I am going to get there later.
All right, sorry.
That's a kind of a punchline, so I'm saving it, Leah.
Sorry for my interruption.
No, that's fine. We're informal. It's just, and it won't take that long to go through all this. Okay, so that's the second risk. The third risk is, again, stated a little differently, but it's really close to the same thing. You talk about incompetent legal services, and they really mean the same thing, but they talk a little more about failures to exercise rights or options, legal rights or options. So they're kind of getting at a more limited case of incompetent legal services where the provider should have said you have the right to do this or do that, or you have this option, and they didn't. But still very similar. Those first three risks are very similar. They have nothing comparable to risk number 4. And given the kind of regulation that's been done on this role in the 2 states to date and in the sandboxes for other things, I've never seen this come up. What those states would have said about this kind of an issue is that either the unregulated legal services are allowed under the UPL law of the state and then nothing needs to be done, or they're not allowed, and whoever enforces those regulations needs to enforce it with those kinds of providers, and that it's not anything special to the LLT role to do that kind of enforcement. that would be considered out of scope. But I think if you're thinking about this more from a program evaluation point of view, it's even more out of scope. You could imagine the regulator addressing that problem in risk number 4 if nobody else had that responsibility. But presumably there's a higher level regulator for legal services in general who should be enforcing that kind of issue already. So in converse to your decision that I just heard, where you kicked out the first one and kept the last 3, I think what you see most other people doing is keeping the first 3 and wouldn't do the 4th one, is the bottom line.
Amos, can you talk a little bit? Because I know Fariba made the case. You know, she usually is at all of the meetings, so I hope everything's okay. She made the case that, and I think it was in response to a question that you asked, Greg. Thanks for joining us. She made the case that adding this new licensee would actually increase the risk of unregulated services. Because now you're going to have people holding themselves out to be licensed paraprofessionals who wouldn't before have that option. Do either of you, does anybody recall that?
Yeah, I can speak to this. Yeah, and we are not writing on a blank slate in California. So there's actually a lot of experience with unlicensed practice of law and fraud that really surround immigration consultants and notaries that are allowed to do some limited, technically not legal services, but to the public it seems like legal services because it's court forms and advice information. And we have heard from prosecutors' offices and the like that this is a real concern. They're already underfunded and understaffed, and this would greatly increase, is expected to greatly increase these concerns. So while it may or may not be something for regulation, it is a concern about creation of the program, and at least it might relate to advocating for increased resources for investigation and prosecution of that. I think our committee hasn't really focused on this too much. I think the discipline maybe has been hearing more about that. But the idea is that if there is some innovative regulation that we're doing here, being progressive and proactive, as opposed to the traditional models, we should at least be aware that creation of this program increases those risks. And part of our charter is protection of the public.
Okay, that's helpful. I mean, I can say one other thing that might be constructive around that. Obviously, you're not going to collect data from the LLTs on this issue because it doesn't involve them directly. It does seem like that's something, if it's really a serious concern, that should be addressed in a program evaluation. But there are 2 kinds of program evaluations: there's so-called process evaluations, and then there's outcome evaluations. And it strikes, and the process evaluations are usually done first, just to see if the program's running as it should before you have data to do outcomes. It seems like this is the kind of problem that you might be able to get early assessments on by doing a process evaluation that includes this component and seeing if it really is a serious problem or not.
Tom, can I ask you a clarification about the competency piece you were talking about? So I think you said in the other model, I think it was Utah, failure to exercise rights or options is how it was framed. Is that as an evaluation or is that as a proactive regulation?
Well, it's actually, there's 2 ways that they get at it. And I'm looking at these again to see if I get this right. They do outcome evaluations. So the risk is that you receive a worse outcome. And part of receiving a worse outcome could be failures to exercise rights and options. So the outcome evaluation is broader than just rights and options. But they don't talk about incompetency. They talk about worse outcomes. But it's pretty close to the same thing.
I think I'm getting these mixed up. Is that number 1, worst legal result? Or are we talking about our number 3, which is competency? And then Utah, it's didn't exercise your legal right.
Yeah, so it is confusing, and I apologize for that, Leah. You could include number 3, the way Utah's done it, as a subset of 1. They split it out because they thought the problem of legal rights and options not exercised was so important that it needed to be separated out explicitly. But yes, you're right. Number 1 is more like just the outcome. Are the outcomes better or worse?
Okay.
And so I'm the one that said that failure to exercise rights or options is closer to incompetency, but part of incompetency could be worse outcomes too. I mean, it could be spread across.
And it might be interesting to you, Tom. I think that's how we ended up here too, although maybe the other way around. I think we started with the large group talking about next best alternative, and then I think our group said what we really want to focus on is incompetent legal services. So I think it's kind of the same thing. There is overlap, but I think both us and the other state, it sounds like, wanted to drill down a little bit more under this outcome. And again, that's why I think we went with outcome. Sounds like more of evaluation, but competence sounds like more of a proactive regulation. Is sort of, I think, how we've been discussing it.
Yeah, and I don't think, I'm not going to quibble at all about the semantics, because like I said, it seems like those first 3 really are the core risks for consumer harm that people have focused on. So I was pleasantly surprised to see that you guys had gotten to almost the same place.
We like the validation.
So do we, since we admire California a lot. So let me talk about data then a little bit. And I'm going to talk about data first from the regulation point of view, and then data from the evaluation point of view. But some of the themes are going to be the same. So from the regulation point of view, everyone learns really fast, the hard way, that collecting valid data is extremely difficult. And it can be costly too. So on the regulation side, where so far we mainly have evidence from Utah, but a few other places too, the strategy seems to be to concentrate on the smallest and simplest set of data that will give you some feedback on the 3 risks and the 3 harms, if that's what you're tracking in your regulatory approach. And it's almost, because that's the case, because it's too difficult and too expensive to get people to regularly report very much data, even a small amount of data, the minimum for those 3 risks, it's really important that you not try and be comprehensive across everything you could think of. They're more like a canary in the mine approach. And the idea is, if you start seeing, alarming data from any of those metrics, then the regulator would step up the intensity of their oversight, either through additional data, more frequently reported data, audits, or whatever was deemed appropriate, rather than trying to impossibly and too expensively collect everything right out the front door. And in fact, Utah has found, and I think a couple other places too, even when they use the like minimum possible data sets for reporting of empirical consumer harm regulation, it's still been really a difficult kind of bootstrap operation to get these providers trained to regularly report valid, consistent data that can be comparable from the regulator's point of view between providers. So that's just kind of a caution to not be too ambitious if you go down that road. On the other hand,
Tom, I don't want to I don't want to redirect you if you're going to come back, but if you're not, I want to ask you, because I'm really curious, for this worst legal result, or the way they've done it in Utah, the outcome would be as good as, and they're using that in a regulatory paradigm. What data are they collecting to get at that? If you're going to answer that later.
No, I'll talk about that a little bit right now. So there's the easy part and there's the hard part. Not that any of it's easy. The easy part are the court outcomes, because it's relatively simple to get court outcome data. And so you can make those comparisons. And the outcome of a legal case that goes to court is fairly straightforward in most cases. So that part isn't too bad. The problem is when you're thinking about the goals of these programs, a lot of cases are to close the act or narrow the access to justice gap or the unmet legal need gap, depending on how you look at it. And 80% of that gap typically doesn't make it to court. So you're trying to evaluate the outcomes people are getting under this program 80% of the time compared to what they would have gotten for stuff that doesn't get to court. And it's really hard to get good baseline data for that piece.
Yeah, we've experienced that, I think, at least with two programs I'm thinking of, the Shriver Civil Counsel Act evaluations, which I don't know if you're familiar with, Tom, but effectively tried to get, I think even in the court outcomes, I think what that evaluation really revealed was the court outcomes aren't really a clear yes or no, good or bad, because there's a lot of times when, you know, for example, in a housing case, somebody might lose their case, settle and move out, but they get additional time, they avoided the judgment. There's a lot of other things that could be a successful representation rather than a sort of a win or dismissal of the case. And with our IOLTA programs in California. So we've gone through a lot of different attempts to collect information and outcome information from IOLTA. That's our interest on lawyer trust account programs. And it's sometimes challenging for the organizations to fill out all that data or to correctly do it, or make sure you're comparing apples and apples.
Yeah, absolutely. All that's totally true. I didn't mean to minimize too much the difficulty of evaluating outcomes, but it's still somewhat straightforward, even though there are a lot of nuances. And one of the things that I've been a part of this conversation actually the last couple of weeks, as Utah starts thinking about doing outcome audits on the front end where they're worried about quality for non-traditional services. So they were going to have lawyers do audits of a sample of cases to see whether the legal outcomes were competent or not. And it's exactly the problem you raised, is that there's a certain number of those cases that you can really straightforwardly and confidently say, yes, they did the right thing. And there's hopefully a very small number of cases where you can say it's obvious they did the wrong thing. But there's a whole lot of gray area between there. So again, they've been kind of forced to adopt the canary in the mine kind of approach. So as long as kind of a typical bell curve number of things fall into the gray area, they don't get too excited. They start seeing things that are clearly wrong, they get excited. And if too many things get to the bottom end of kind of a scale of gray things, then they start getting excited again.
Are there any kind of consumer outcome surveys, so sort of satisfaction?
I'll get to that on the program side. So let's go to that.
Well, can I ask you a couple more questions on the regulation side?
Sure.
In any instance, would anything that is found through these processes serve as a basis for discipline or removal of somebody from the sandbox?
Yeah, so let me just say what kinds of data is being collected. I'll miss some things, but you'll get the gist, and then I'll try and answer that. So where the sandboxes are being used, they have increasing levels of data requirements depending on the risk, the perceived risk or expected estimated risk. So on the low end, you've got mainly consumer complaints. And think of consumer complaints in this instance, not like bar discipline or malpractice complaints, but as, Yelp complaints. It doesn't have to be on Yelp, but they're consumer complaints in a less formal, less serious, more broad kind of way. And those consumer complaints can come in several doors. They could come into the provider and then be reported to the regulator, or they could come directly to the regulator. Couple different ways they could come in. And of course, some of the problems with the complaint approach is that not all complaints go to consumer harms, right? A lot of them don't. A lot of them are, the person I dealt with was snippy with me, and I didn't like it. Well, you may be unhappy about that, but that's not necessarily a consumer harm that a regulator cares about. So you have to kind of separate out a subset of the complaints that actually go to consumer harm and risk. But that's kind of the starting point. From there, of course, there are sets of data that get directly at the objective outcomes and the comparisons of the outcomes to the baselines. So that kind of stuff gets evaluated, as well as your concept of incompetent legal services or Utah's concept of rights and options not exercised. Those can be evaluated directly in the case of the courts from the data. And when you get to the riskier types of providers, of which this would not be an example, triple LTs are not considered riskier providers in most states. People start doing things like audits of subsets of cases or secret shopper sampling, where they try and get at whether the results are better or worse or competent or not by doing, sampling small numbers of cases and then having experts evaluate them. That's, of course, expensive, requires a lot of process, a lot of training, a lot of money, both to collect the data and to evaluate it. So that's why those aren't done routinely. Those are only done for the riskier types of providers, which I'm going to say again, triple LTs are not considered to be by most states. They do want to do program evaluations for sure. They just wouldn't do routine. They wouldn't do those things routinely. Anything else, Leah, before I move on?
Well, I'm not sure you answered my question. If any of this could ever be used for individual action. Like,
oh yeah, sorry, I forgot that. Thank you.
Yeah.
Didn't mean to avoid it. Yeah, so then the question is, if you're doing this kind of consumer harm risk regulation, how do you respond when you see those red flags? So it's a little easier for the sandbox approaches, I think, than it is for the kind of role that you're dealing with here. Because in the sandbox, their ability to do it at all in the first place is a waiver granted by the Supreme Court to pilot something, right? So anytime the Supreme Court's not comfortable with their behavior as a provider, they can do anything they want, starting with providing more data or more often to throwing them out of the sandbox and everything in between. But it tends to send, because it's not the discipline of an individual with sandbox, it's the regulation of an entity or a provider. The punishments tend to be more like stopping you from being able to provide the service, which is pretty different from a role like a triple LT, where your disciplinary approach is analogous to lawyers. And I would assume that the disciplinary steps you would take would also be analogous to that.
yeah, but ultimately it's the same potential outcome, like stopping you from providing the service. Like,
yeah, you could, but
license.
One reason that the sandbox programs have gone to the strategies they have is because there's a widespread belief, with almost no evidence to support it, that the traditional lawyer disciplinary processes are extremely inefficient at finding bad performance.
So I'm not exactly sure where we are. We've gone through data for regulation. Are you good? Are we still going through that?
No, I'm ready if you are to talk about data for program evaluation.
Well, the only thing is, I feel, and Amos or others, if you think I'm still not clear on the data that's actually being collected to determine a failure to exercise rights worst case outcome? Because you said it was easy with the courts, but then we have the example where it's not. And I certainly wouldn't think it would be easy using court data because you have bad outcomes with attorneys all the time.
Yeah, you do actually, about 25% of the time.
So how do you, how aside from the court data, what are the actual data collection requirements that are designed to get at this issue?
Yeah, so I apologize, Leah, I don't have the data sets in front of me,
Okay.
but I can easily provide them to you. And I'll do that offline.
Okay, that would be helpful.
Yeah,
No.
but let me just caution you by saying that it's not immediately obvious in some cases how the data connects to one of the three consumer harms. And in fact, just so you don't feel bad when that happens, it hasn't been immediately obvious to the people regulating these programs in other states what that connection was either. So I will provide that to you offline, but there may need to be a little more back and forth about how that data actually gets to those analytic results.
And as far as you're aware, I think you said that there are not audits or self-evaluations for the other triple LT type programs. I thought we saw some examples, at least on the Canada one.
Oh, there may be for Canada. I can't speak to that one.
But on the other one, so there's no, as far as you're aware, there's no self-evaluation or audits or that kind of what we've been calling proactive regulation.
No, not at all. For Washington and Utah both, they regulated on the front end, just as you are proposing to do, and they did program evaluations, both process and outcome in both cases on the back end, but they were program evaluations. They were not back end regulation.
Okay, are we ready to move on to talk about evaluation? All right.
Okay, so data collection for program evaluations. I sure wish I could be a cheery person about all this stuff, but in fact, it doesn't get much easier. In some ways, it gets harder because, as we've already discussed a couple times, the data sets that you want are broader for program evaluations. And in a lot of cases, they're harder to get because, particularly because for some things like procedural satisfaction of the consumers, and you can kind of you yourselves have made a list of things that require surveys. Anytime you have to do custom survey data collection, it's expensive. Even for program evaluators, it's expensive. And it's even difficult in some cases. One of the things that people often want to know for program evaluations is there bias, is there discrimination, is there inequality? And so they want to know demographic data like what's their race, what's their ethnicity, what's their age, their gender, their level of income and education, so they can determine if there are instances of bias or discrimination. We have found not just for program evaluations of these kinds of legal roles, but actually for program evaluations of almost anything related to the courts or the legal world, or indeed other worlds. When you try and ask people who are the consumers of a service that kind of information, they'll often balk. And if you tell them that the price of admission to using this program is mandatory provision of that kind of information, they get really angry. And in some cases, they just walk away. So not only is the data harder and more expensive to collect, but in some cases, it's just really hard to collect it at all. Not that you shouldn't do so, though. Leah, let me add one thought before I forget. So I think you need to this is an editorial, so let me be clear, this is just my own opinion. Most of the time I'm trying to report facts about what people have done, but this is an opinion. I think you need to be careful about mushing regulation and evaluation together. And the reason is because it's very useful to have program evaluation be as independently done from the program as possible, so that the legitimacy and validity and the the chance that people will accept the results is greater if those program evaluations are done by someone who doesn't have a connection or an interest in the program. And you'll see that both in the case of Washington and Utah, both for the sandbox and the triple LTs. In every case, they had an outside group that wasn't connected to the state or the program do the evaluations, so that when they had conversations politically about whether the program was succeeding or not, should continue or not, there wasn't a conflict of interest or some kind of vested interest. So keeping those two things apart is actually a good idea.
So I just feel like for me, it would be helpful to kind of work through this. So let's say we wanted to regulate the quality of services, whether we call that competency or whether we call it worse legal outcomes. We wanted to proactively regulate it. So not in a way that it's regulated now. That would mean that we would collect data on individual case outcomes or transaction outcomes that we would be able to compare to some alternate scenario or some baseline data. So we'd be able to say, for this case that Amos did, paraprofessional Amos, case X, the outcome on case X is what we would expect it to be based on some benchmark standard, or based on what attorney Brady got the same result for a similar case. Like, I'm trying to figure out, how would it even be possible to do this from a regulatory standpoint? From an evaluation standpoint, would it simply be trying to aggregate case outcomes overall and saying, okay, well, right now, for cases where an attorney is, where both parties are represented in, I don't know, contested family law cases, the outcome is typically X. And we see at the aggregate level in cases where both parties are represented by paraprofessionals, you're seeing a similar result. Like, I'm trying to figure out at a regulatory level, at a program evaluation level, how would we possibly look at?
Yeah, so those are just great questions and really difficult ones, but let me do my best to get a toehold on a couple of them. Let's start with the kind of high-level aggregate evaluation that you talked about at the end. In some cases, I think you could do that. So I'm going to give you one example. In consumer debt cases, there's a really high level of defaults. So we know that in many of those cases, the consumer on average would be better off if they negotiate a settlement, or in a few cases, probably even take it to court. They would almost always, but not always, but almost always be better off if they didn't just default. So one way you could get at that would be to look if people who used the program had a lower percentage of defaults in consumer debt cases than people who didn't. So you could do some of that in certain cases where there are simple metrics like that that might be appropriate, but that's not going to work for a lot of types of legal action, unfortunately. And then you'd have to get more into the nuances. So there's kind of two general strategies there, Leah. Maybe there's more, but I'm only smart enough to think of two. One strategy would be, for a particular type of legal problem, you could build a decision tree basically for that use case, or that collection of legal facts. So if this happens, these decisions should be made. If this happens in the case, then you should make this decision. And you could kind of flesh out these complicated decision trees for what ought to happen in particular types of legal cases. As you can imagine, that's a huge amount of work to do that. And some states thought that they might minimize that amount of work to arrive at the analysis of better or worse outcomes by stealing triage and decision trees that legal aid organizations had used in certain case types. We know they exist. I know they exist from projects I've done in past years in other areas. But when we tried to extract those kind of decision trees from legal aid organizations as models for correct legal advice and handling of a case so we could determine if the outcomes were better or worse. It proved really difficult to get those decision trees. So that's one strategy. It's hard to do. A strategy that sounds a lot easier would be to just get a group of experts together. Usually those experts would be lawyers, and just give them the cases and say, is this outcome better or worse than the benchmark based on the data? And they have to go through the nuances of the case and decide whether that's true for each case. That's a huge amount of work. So again, expensive. You wouldn't do that routinely. You couldn't. But beyond that, there's no guarantee that one lawyer is going to evaluate what ought to have been done in a case the same as another lawyer, because there's lots of gray areas in the law, right? Lots of subjectivity. And that may even be due not just from the facts of the case, but the provider, which in this case, LLT, may not have provided them enough nuanced data to be able to make calls about whether a gray area makes them better or worse off. So then that raises all sorts of issues about what kind of training does the evaluator need, and what kind of protocols should they follow when they're doing the evaluations for consistency across the evaluators in the results. And what kind of data does the provider have to provide so that the evaluators can do a valid and consistent evaluation? None of these things have easy answers so far. It turns out that, just as you're surmising, it's easy to say evaluate the outcomes against a baseline, but it turns out to be a lot harder to do in real life than people thought.
I think, so I'm interested in talking about that last alternative, sort of have experts or attorneys do some sort of evaluations, because that may be possible or more possible in a kind of a pilot program. But I think there is a third alternative, at least from a social science point of view. I think the normal way to do it would be to have some sort of control group, where a control group with similar issues did not get the services. And I think that's what was attempted to do here in California in the Shriver Civil Counsel Act evaluation by a third party evaluator. But that also is expensive and has a lot of challenges.
Yeah, in theory, you could do that statistically. And in healthcare, they do some research that way statistically. And one thing that really annoys me is that I'm convinced that Westlaw and LexisNexis have not only the data, but have already probably done the analyses that would tell us that kind of information, at least for the baselines before you implement the program. And if you gave them the program data, they could probably do that too, but it's all proprietary, so we can't get our hands on any of that.
And it would be really hard to figure out what your comparable case, like if you want to do a random controlled trial, like how do we know that my case is the same as your case? They have to be kind of the same cases going in two different directions.
Yeah, so it has been done in a couple of cases, Leah, that I know of, not for LLT so much, but for other roles like navigators, but a little bit for LLTs. But the way they've done it is to pick really simple instances. So they're taking housing cases or eviction cases where there may be 8 branches to the decision tree. So then it's relatively easy to figure out what's comparable and do the evaluation. Like Becky Sandifer and I did that for the navigators in the New York City Housing Court. And we were able to do the comparable outcome evaluations, but it was because those are relatively simple cases and there's only a few branching decisions. So it's pretty easy. Get into something more nuanced, then yeah, it becomes a big problem.
Mm-hmm.
I think I've also seen it for limited scope services by lawyers.
Yeah.
In Massachusetts. And so, yeah, I mean, it's expensive and challenging, but I think I am convinced, and I bet it's generally the case on the working group, that there needs to be some type of evaluation of this program. And so just figuring out what that looks like, I think, is an important aspect of putting this proposal together.
So here's a ray of sunshine about that. I'm glad you mentioned the unbundled limited scope services, because one thing we know from the Washington and Utah programs is the people that are the target consumers for those kinds of providers. One of the things they hate about lawyers is paying by the hour. because they're full service lawyers and they don't want to just say this is what it's going to cost. And one of the things that they really want from triple LTs are limited scope services with fixed prices. Now, a lot of the triple LTs, particularly in Washington, still billed by the hour, but some of them actually made that transition partly under consumer pressure and broke their services down, the allowable services down into fairly repeatable limited scope tasks, like within family or some other legal area. And then they could charge fixed prices for those tasks. Well, one unanticipated benefit of triple LTs running their practice that way is that then those tasks would be relatively straightforward and it would be relatively easy to evaluate whether they produced a better or a worse outcome on those tasks. But note that that requires you to think about the evaluation, not in terms of traditional cases, but in terms of the limited scope services that a provider provides.
Mm-hmm. So it sounds like for this one, and if I'm just correct me, but we aren't thinking about this for proactive regulation. We're thinking about it for program evaluation. This one being case outcome, using that as a broad header for competency, for worst legal result, for all of that. And then we're talking about a couple different ways to get there. So audits by some panel of lawyers looking at actual case files and opining on what should have happened. Some kind of random control trial. And sounds like there's models for that with the court navigators in New York, maybe something that was done, I think you said Amos, Massachusetts, on unbundling. And you're just saying, Tom, that if our paraprofessionals break their services down in a discrete manner, that might facilitate this analysis because you're not looking at the entirety of the case outcome, but you're looking at the outcome of, I don't know, filing a particular motion or, you're not having to look at the entirety of the case, and that would make it easier.
Yeah, that is what I'm saying. But remember that if you're doing a program evaluation, you're evaluating a longer, broader list of things than you are when you regulate. So beyond outcomes, which you could get at that way sometimes, I'll just do a list of some of the other things that you would probably want to look at in a program evaluation. You'd want to look at the level of use first. So are people actually using triple LTs? And if so, are they using them with enough volume that it actually makes a difference and it's a viable program from the provider's point of view? Of course, outcomes we've talked about a lot. Procedural satisfaction would be something you would want to measure by customer surveys. Are people happy about how they were treated, regardless of whether they won or lost, that kind of thing. If you could get the data, which I argued is hard to get, you'd want to have the program evaluator look at things like bias and discrimination and equity. And then finally, there's a couple of measures that an evaluator would hopefully want to look at, but they'd have to wait a couple of years to do it, around the program viability and legitimacy. So viability would be, does the program have a stable source of funding? Are the front end requirements for training and certification affordable so that people actually do it because it makes business sense? Do people make enough money to stay in business? Those kinds of things. And then legitimacy really goes to, maybe the program works, but do the lawyers and the judges and the consumers, any one of them, think that the programs are bogus and don't provide, good services? Whether they do or not, that's a separate issue that you have to get at with surveys as well. So that's a long way of saying different data collection methods for different measures in the program evaluation.
And I assume this also can be expensive and difficult, and we have to be cognizant of the burden we're placing on licensees if we're collecting much of this information directly from them.
Absolutely. And then, you know, this is something that's kind of like data collection 101 to people who do it for a living, but you'd have to not only do a really good data dictionary where you describe each data element very formally, as well as what it means from a business point of view and how it's to be collected in your kind of data collection protocol. Then you'd have to train the providers on that protocol. Those definitions are, and we found that even then they can screw it up if you have them provide the data. And so one way to minimize the screw ups from the providers is to create a data collection instrument where they don't have the latitude to make up the answers. They're forced to choose between a finite set of fixed answers when they're reporting the data. All those things are kind of typical methods of getting consistent data. But what most program evaluators do, frankly, because they're serious researchers, is they just create the data sets themselves. They don't try and get the providers to report them.
Based on this conversation, Amos, are you thinking about any of these in a regulatory construct? As I am trying to like really be clear about those distinctions. Like I'm thinking about price. If we were to set fee caps and you wanted to regulate the implementation, right? You could presumably do secret shoppers or auditing to say, okay, we told you you can only charge, you know, $100 for X service. Now we're going to go in and we're going to audit half of all the licensees and see, are they really charging, is anyone charging more than the fee cap? That would be regulatory, right? Not evaluative.
So here's where my mind is now, but I think this should be a discussion. I mean, I think I do like having a bright line between evaluation and regulation. And Tom, as you suggest, I think there's really different purposes and different data you collect, and maybe you want evaluation to be more independent. So I would like to keep talking what you're talking about, you know, where is this regulatory? I think it should be a different committee that talks about what program evaluation looks like and is the program meeting its goals. For regulation, I mean, I want to be cognizant of the burden on the licensees, because I do think we fundamentally have the normal approach to regulation here, not the new progressive proactive regulation. But with that said, I do think we could collect some information from licensees in a non-burdensome way to just check on them and check on the program. For fees in particular, if there's a bright line cap, that's easy to regulate. The issue is if there's not a bright line cap, how do we regulate? And that's where I'm not sure. But competence, again, it sounds like it's very difficult to do that in a proactive regulation way.
And so we had three, not Tom's three. We had excessive fees, competency, and fraud. Fraud is also, I don't think it
by non-licensees.
Fraud by non-licensees doesn't lend itself to proactive regulation.
I mean, I think where I am on that is that should be something that we propose, maybe along with the disciplinary committee, of some way the bar should be addressing that. That's a little bit beyond the scope of our working group, but that there should be, you know, maybe increased funding for, you know, consumer protections on that, because we do expect there may be increases in fraud, but that it's not necessarily going to be regulated by the bar.
So I think where we're getting to is we could dig into fees a little bit more, but that's kind of the last man standing of the risks from a proactive regulation standpoint versus evaluation.
I think what we talked about, and we looked a little bit at the Canada forms, and sorry, that's been a little while since I looked at that, but it seemed like there was some useful information that could be collected through self-evaluations, or they called them audits, or what have you, in sort of a data collection. But again, a lot of it seems more like an evaluation rather than a regulation on the disciplinary side. So I think we could give some thought about whether we have some model, but I think we should be cognizant of not being, too burdensome. And, if there's some other way we could attack the fee issue, which I think we're discussing, either fee caps or some sort of disclosure model or some sort of some other ideas. But I'm not even hearing, if we wanted to do that through proactive regulation, how that would really be effective. I think we could certainly collect information about what fees licensees are charging, but we still would have to create some sort of model of what is a reasonable fee and what is not, and decide what to do when we get that information.
Are you familiar, Tom, with what they're doing in Ontario?
No, not very. You'd have to ask Becky Sandifer about that one.
Well, we are in communication with that program. So I'm wondering, I just don't, and Linda, maybe I don't have a good handle on what they do in this regard.
I'm the wrong person to ask anyway, because I have an economics background, and the idea of setting fair fees seems
no, I'm not talking
odd to me.
Ontario does not cap fees. It's they have I thought they did an audit.
They do an audit. They do an audit, and they ask, they require the paraprofessional the paralegals to complete some forms and provide information.
Yeah, you circulated that, I think, Linda.
Yes.
And I think
She did.
I would,
can't remember it.
Yeah.
This brings up indirectly, though, something else, Leah, that I want to mention, if you'll allow me to. One of the really surprising things we found in Washington, and I think it's going to happen in Utah, but I'm not sure yet because it's too early, is a lot of these paralegals that ended up doing the LLT programs, they had worked, as you would imagine, their whole careers for law firms or related to law firms in some way. And very few of them had operated fairly independently. And so when they were offered, when they created this role, and basically they're running their own businesses now, almost none of them had any training in how to run a small business. This was something that nobody had thought of on the front end. So none of the 3 years of training that was required for the Washington paralegals had anything about how to competently manage a small business. So a lot of them ended up, even though they were LLTs, just going back and contracting with traditional law firms, part-time or whole-time, both, and kind of shoveling that off onto the law firm, the management piece. And relatively few of them actually went out on their own and as a separate entity and had to figure out what prices to charge and how to make a profit and things like that. And the ones that did, many of them failed because they didn't know how to do it. So it turns out to be a surprising factor for success is somebody involved with the LLT has to actually know how to run a small business. The reason I bring this up is because part of being able to run your small business successfully is knowing what price to set. So if the LLT is working as an employee, part-time or full-time for a law firm, which a lot of them did in Washington State, that problem is solved for them. The law firm decides what price is charged, and they always set a price significantly below a lawyer so that they're attractive to use their services. If they're by themselves, they have to analyze all that themselves and decide what a reasonable price is that they can make a living off of. And surprisingly, few of them were able to competently do that.
Yeah, this just came up, I think, at our last licensing subcommittee meeting, just the kind of the need to include practice management, how to run a business in the mandatory training. But I want to make sure that we're moving towards where we need to get to, because the regulation subcommittee is supposed to bring forward a recommendation on proactive regulation at the February meeting. It sounds to me like we're moving mostly away from having any recommendation in that regard, with a couple caveats, and moving into the evaluation conversation, which is yet another deliverable for the working group. But I think we're not completely done with the regulation concept. So there's the Canada model, which we can refresh our recollection on and see if it makes sense to invite them to talk to us. Is there anything else that would be helpful, Amos, since you're one subcommittee member on the call, for you in terms of taking this, kind of reaching a conclusion on this topic?
Yeah, I mean, I'd be interested, Tom, if you have thoughts. I think when we have been talking about proactive regulation and looking at, I think some other materials, not just about the sandboxes that you've been focused on, which is very helpful, but I think broadly speaking, what is proactive regulation, and sort of here are some ideas of what proactive regulation looks like. That would include CLE, for example, because that is not to get the license, but just continuing education. To proactively prevent, competence issues is make sure people are, engaged and continuing to learn. So I'd be interested, just generally speaking, not tied to these other programs, but do you have ideas about what options there are for not too burdensome regulation that could avoid sort of incompetence or public harm?
Yeah, so I have some thoughts, but I don't think they're going to make you very happy or be very useful. But I'll tell you briefly what they are. So the traditional front-end regulation, all those things, the training, the certifications, the CLEs, all that, those are all to prevent hypothetical harms. This is essentially a data-free industry. We actually have no idea how often any of those harms occur, how big of problems they would be in the absence of any of those things, or if those things were modified, if the CLEs were eliminated, or the training was cut in half or redesigned, any of that stuff. If the rules 5.4 were modified, as many states are doing now, we have no idea what the impacts of those things are. We don't know what the impacts of those things are in the traditional lawyer market. Almost no data. So that's my first comment, is you're creating these kind of traditional requirements on the front end patterned after lawyers that we have no idea how cost effective they are or whether they're appropriate to address the hypothetical harms that everyone worries about. We just simply don't know. The extreme perspective that one might take is that you could treat the whole world like a sandbox. This is the other extreme. You could put lawyers and triple LTs in there in the sandbox with everyone else and do empirical consumer risk-based regulation and forget about all that stuff and just let your regulatory data tell you whether people are causing problems or not, either individually or as a class. Nobody is willing to do anything that extreme, for sure. And to date, really, there's only 3 strategies to date. Either they're doing the front end strategy, which is what everyone's done with triple LTs, or they're doing the back end strategy, which is everyone's doing with sandboxes, or they're doing the nearest thing to a compromise, which is fiddling around with eliminating aspects of Rule 5.4 and 1 point something, I can't remember, selectively, and seeing what happens with the bar. And that's really it. This kind of a mixed model or a compromise or a hybrid. Honestly, I don't have any data to report about that strategy.
Right. But no, that's helpful, I think, just for framing it. And again, I think I've come with a little bit of a different framing than some others on the full working group about, we're not writing on a blank slate in creating a new licensed professionals. California has a lot of different licensed professionals, and they are regulated slightly differently than attorneys, and that's not necessarily a bad thing. and there are consumer protections that, you know, we could use from, you know, any licensed professional. But for, I think to answer your question, I think what would be helpful is to know if there are some other models, maybe the Canada model, maybe Rebecca Santafor could provide us information on that, because I think there may be something we can do that may be more limited than we were originally thinking, but some sort of self-evaluation or audit or annual information collection really in connection with or separate from the evaluation, which I do think it would be helpful to separate that out and maybe have evaluation subcommittee, because that's a whole different, I think, thing that we need to do from regulation. But I do think, you know, at least I'm leaning towards not having significant proactive regulation as part of this, and just seeing if there is one or two things we want to include that wouldn't be too burdensome.
So let me just talk about one thing that might be more like what you're looking for, you and Leah are looking for. So there is one class of provider that's a new type that we have a little bit of data from that I think is going to be really interesting. I'm fascinated to see what happens with them. And there are longstanding examples in the UK that have been well studied. And then there may be others, but the one I'm most familiar with is Arizona is setting up something similar now. And this class of role is where they take a non-lawyer, not a paralegal, and train them to do some small, specific, narrow set of legal tasks, specifically and nothing else. And what happens is, if that's all they do, it turns out that they can be trained really quickly and cost effectively to do those things at a reliability equal to or higher than a full service lawyer. The trick is to identify those really narrow, specific ranges of tasks that role can perform. So in Great Britain, where that's common, it has been studied with the results I just reported that they do as well as full service lawyers, but they're narrower ranges, they're narrower scopes for the roles than what you're proposing for the triple LT role in California. In Arizona, it's the same thing. They're proposing narrower scopes, although kind of a compromise between the UK and what you want to do with your triple LTs. And they're proposing training them in like a month or two from scratch for a minimal amount of money.
Are you talking about the DV specific trip? Because they've got two different programs being contemplated in Arizona. One is broader and one is super narrow. You're talking about the super narrow DV focused one.
Actually, the one that's more interesting is the little bit broader one that's not a triple LT program.
And that's still a month?
Well, none of this is for public consumption yet, Leah.
Oh, okay. All right.
They're still developing their programs.
Okay.
But depending on how wide you set the scopes for the roles, some of them could do things like, let's say you set a role to fill out divorce forms. Yes, for something like that, if all they could do is fill out divorce forms or child custody forms, something like that, they do envision being able to train people in a couple of months and setting them out to do it.
Okay. So we have to end in 4 minutes. What I'm hearing, Amos, is certainly we're going to bring back information on Canada. I will pick Tom's brain, Becky Sandifer's brain, see if there's any other ideas, because I'm not sure that the purists would call CLE or self-assessments proactive regulation. So we might call it that, but I think they're going to call it something else. But under that, I understand what we're talking about. So see if there's any other idea. I mean, we've got the self-assessment they do in Illinois for attorneys. So there are models for self-assessments. So we will bring that forward, and then I think kind of make at least a preliminary decision about what to bring forward to the full working group. That's my marching orders. What I take as my marching orders.
That sounds great.
Okay.
But I do think we have, again, as we dig, we find more work. The evaluation part of this is, I think, important and is going to be a hard nut to crack. But I think the program has to have some sort of evaluation component to it.
Yeah. We just came up today in the pilot subcommittee meeting, and we can talk to Justice Petra about how she wants to handle the evaluation piece. We do have a lot of ideas that have already been generated on that, and I think even just putting them together will be helpful.
Yeah, I'll note, I haven't been participating in the pilot subcommittee, but it does seem like the evaluation that Tom mentioned, where you have experts like attorneys actually reviewing cases, if it's a small scale pilot project or even supervise, I think they were some idea of you should actually have attorney supervisors. It seems like that does, it might be more workable on a smaller scale. But I think that might be more for the pilot program to consider, unless they think we should consider it.
Yeah, I don't know. Let's see what Justice Petra wants to do. So our next meeting is on the 4th. I can try to tee this up for the 4th so we can kind of finish this discussion, or we can go back to the rules. If Greg, you think we need to go back to the rules, we do need to go back to the rules. We're not done.
Go back to the rules, just to actually look at the resulting amendments from some of the decisions we made on the policy, the underlying policies on some of the rules. And then also, Amos, we haven't really gotten into drilled down on your suggested disclosure rules and informed consent, and where those probably fit in either in the rules of professional conduct or in the court rules that'll stand up the program. So I think we need to have that conversation.
Oh,
And I
that'd
think
be great.
Let's go back to the rules for the 4th, and that'll give me time to pick Tom's brain and Becky Sandefur's and Canada and others.
Okay.
Okay.
And I think we have a conflict on the 9th for me,
Right.
so if we could try to
Yeah, we'll
reschedule
reschedule
that.
that. All right, Tom, thank you so much.
Very nice to meet you, Tom. Thank you.
Yeah,
That was
you
very
too.
helpful.
My pleasure.
All right, thanks.
Bye, thank you.
Bye.
Yeah.